Yes. So guys, happy morning. Welcome to Shree Rajamathangi Academy. We have almost completed chapter number 2, but what is pending is the last minute revision, one-liners. That one-liners, if we complete, it should be easy. Now that will take you through. This is going to be the fag end of your examination. Or maybe on the exam day, if you try to revise all this, it should be very easy. This is how it's been framed for. Okay, now we'll go for it. What is chapter number 2? Incorporation of company and matters incidental thereto, incidental matters thereto, whatever. Types of companies, we already told camel. You remember? Yes, we told it in a separate way where we told separate PDF notes has been covered and done. Characteristics is only for you to know. Mostly, I will say in some places, you will have to glance this. Going concern concept, separate legal entity, limited liability, etc. Promoter, we already told ABCD prospectus. You remember? The name that will be included in the annual return. Then the board will try to get
Board of
their
Directors,
board of directors, then control over the affairs of the
over the
company.
affairs of the company.
Yes, all the directors will also look up to promoters. All that we told, and we made it very, very strong. Definition of promoter, yes, we told directly. And where it is defined in section 2, subsection 69. Don't worry about subsection. I told you any definition you can say section 2. That's easy. Minimum number, maximum number, we already told. 1, 2, and 7 for one person, private and public. Maximum number of members 1, 200, unlimited. If you remember, directors also we told you. Remember,
15
directors
members.
is 1, 2, and 3. One director for OPC, 2 directors minimum, 3 directors minimum for public company, and for maximum it is 15. So we also said when it is going to be beyond 15, we need to pass what resolution? Special resolution plus alteration of articles. Please also remember this and write it somewhere so that you know when you wanted to increase it, just like that you cannot increase. Section 14 has to be informed. Section 14 has to be complied. What is section 14? Alteration of articles of association. Correct. We would have studied in chapter 2 saying everywhere you don't need to change MOA, but in many places you will have to change AOA. So that we made it very, very, very strong. Yeah. So that's going to be there, very important. Please write it. Minimum directors is 1, 2, 3. That's absolutely no problem. But maximum, even for one person company, there can be 15 directors. Members only is 1. Directors can be 15 also. Are we clear? This point alone, we would have taken it very strong. Can a company function less than minimum number of members for private and public? We already told this. You remember when we were talking about one-person company, section 3 and section 3A also we told. Not more than 6 months it is allowed. Till 6 months you can be. We told there is a death or an incapacity to contract, or they are not able to do because of insolvency, becoming insane. All this for 6 months it is allowed. After that, whatever the debts, it will be personally liable also, we told. Full debts, it will be liable. Incorporation of the company, we covered this. Section 7 has 9 points, and then minimum 7 compliances also will be there. For that, we gave an explanation. For incorporation, we need to do something called run. What is run? Reserve unique name. And ROC will ensure that there are at least 6 names that they should be reserving, and the timelines and all we told. SPICE, what is SPICE? We already know. What is SIN? Corporate identity number, identification number. And when we were talking about this incorporation, the last step is order of the tribunal. Order of the tribunal is going to be based on what? If at all there is going to be any false information or fraud declaration, which Companies Act section you will go to? Section 447.
Punishment.
Section 447, punishment for fraud. Where we will study this? We will study this in prospectus and allotment of securities. Though section 447 will be there in miscellaneous, But for Companies Act, if you wanted to know what is 447, I will show you the chart that is there in chapter number 3. It is not actually there in the new study material, but they have quoted there. I have taken the chart from the old study material. I will show you that it's going to be crucial. Then there is a false information or fraud declaration. Order from the tribunal will be there. Don't bother about this triple FA, but there are 5 ways that we have a case-based question, which we already told also. If you quickly remember, they'll change from limited company to unlimited company. They will change the pattern. Then winding up will be done. Then the nature of business they will change. Then any other order of the tribunal will be done. So that's called UC1. This is going to be very important for your case-based question. Please try to mark it important. I have already told this also when we covered. OPC, 1 member, 1 nominee. They cannot be minor. The amendment is 120 days now. So we told very clearly, OPC won't go with Section 8 company, won't carry NBFI, will not change into any other company, even if it's a small company. Small company means they will change. This point, 19 and 20, is not there in your study material, but if you want, you can note it down. If you want, you can note it down. It is not there in your study material. But what they are telling is, for 2 years, you cannot do anything with that 1% company. Unless 2 years expired, it cannot be converted into any, but when it is within the limits of the small company. You know what is the limit of the small company? Paid up capital, turnover and all we told? Yes. Within that, if you wanted to, then conversion is allowed for paid up capital and turnover. Please take down this alone for 19 and 20. This is for your knowledge only. Knowledge perspective only. OPC, anyways, we have extensively covered in the study material, from the new study material, but this is for your understanding. If at all they wanted to change, yes, when it is within the limit of small company, because 1% company and small company is a part of what company? Private company. Correct? No, correct. So you don't need to bother about that. You can easily do. You don't need to wait for 2 years. Based on the paid up share capital and turnover, you can do. And based on the rules, it is 4 crores and 40 crores. We told that numbers, guys, when the moment today, when I will complete chapter 2 and start with chapter 3, what you will have to do is, whatever we colored with the numbers, you are writing it in a separate notebook and studying. So that when you touch your RTP or MTP and all, you will be able to get the answer like this, irrespective of whether it is MCQ or scenario based question. Okay, the time limit you cannot search during the examination. It will be very tough for you to find out. EPA, if you write one after another, it becomes very easy. When you wanted to get an exemption or when you wanted to get a best paper, all India's best paper, I think that's the only way. I have trained a girl on that also, and she got an all India best paper for law. That means overall in India, her paper is the best paper. So whatever I told she did, and she was able to get that. So why I am saying this is, there is always a possibility that you can get. If you can, don't just study what I'm given, but if you prepare smart works and smart PDF, it should be very, very helpful. And obviously some mnemonics also. Section 8 application, we already told case CSR, protection with environment, commerce, art, science, education, religion, all that we have told. Can you distribute dividend in Section 8 company? No, not allowed. Now, these type of negative questions are there. No, this also they will ask you in your examination too much. More than positives, they will say what is not allowed, what is not going to be allowed, what is an exception, what subject to do if you do this. These type of tricky things alone, if you take separately and write, that also is going to be there. So now why I colored dividend distribution not allowed for Section 8 company, profit itself, if it comes also, you should apply it only for the object. How will you distribute dividend? So chapter 8 will have no connection with section 8. Easy to remember. What is chapter 8? Dividend. What is section 8? Non-profit company. Section 8 will never go with chapter number 8. Easy to remember. So that's like a negative type of a shade, which easily they will ask you as a question. And they will also tell one this in chapter number 4. Bonus cannot be issued in lieu of dividend. Instead of bonus, you cannot give dividend. Instead of dividend, you cannot give bonus because bonus is share. Dividend is cash or bank. Instead of share, can you give cash? No. Instead of cash, I should give you 10,000. Now I am giving Priya some 1,000 shares. Will she get it? No. That is not allowed. If she might get or she might not get it, but that's not allowed. Instead of shares, how I will give money? So that also they will say. Now see the connection. Section 8 is interconnected with chapter number 8, is interconnected with chapter number 4. What is there in chapter number 4? Bonus issue. So that we should try to understand. Okay. So that is going to be that. I will also tell this, so it should be very helpful. You know what I'm connecting now? Section number 63. You can ask me what is section 63 directly. What is section 63? Bonus issue. Where it will come, chapter number 4. Now this connection like this, if you study, I don't think you will have any problem in getting an exemption. Bare minimum, you can get an exemption. Okay. So section 8 is only for what? Only for promoting the objects. Who will grant license or who will reject or revocate the license for section 8 company? Central government. Now see this point and this point. Central government will issue the license. Revocation also will be done by central government. Even a firm can be a member of section 8 company. So section 8 company means only company should not be there or only individuals. Even a firm can be there because it's non-profit organization. Anybody can be a member. That also they will ask in a case-based question. If you wanted to convert from section 8 company to another company, you need to pass what resolution? Special resolution. Please understand this. If you remember the chart when we were talking about, if section 8 compliances is not done properly, central government will force you to convert it into private company or public company because you are not using the profit for the objects of the business. You started with one purpose, but you are getting your own profit. Unlimited liability means it's firm. Limited liability means it will come to company or it will come to LLP. Now they will ensure you are properly taking care of the section 8 company. Otherwise, they will convert also into a private or a public limited company. So if you voluntarily wanted to convert, you are no more for not for profit, you are for profit only. Okay. So all the obligations of the private company or public company will come to you if you are not going as per the compliance of section 8 company. Am I clear? Yes. So next one is section 8 exceptions. I told you exceptions means CA Institute will be very happy or CS Institute will be very happy. That means what and all will not come directly, that they will ask. What are the exception? Usually 21 days notice, but for section 8 company 14 days notice. Usually there will be an ID. ID means what? Independent director, but here minimum ID not applicable. You need generally for nomination of director or for giving remuneration, you need a committee. Here no need for NRC. What is NRC? Nomination and Remuneration Committee. Usually to address the grievances of these stakeholders, there will be a relationship committee. Here nothing is there. All this when it will come. For profit only they will come all this. For non-for-profit, why they wanted to come? So they don't wanted to. So no independent director, no NRC, no SRC, no 21 days notice, only 14 days notice. This type of question you can always expect from the CA Institute to ask in the case-based question. So I will color this. Who is an ID? Independent director. Who is NRC? Nomination Remuneration. Who is SRC? Stakeholder Relationship Committee. Effect of registration, we already covered in the chart. You remember? In the institute material chart, we covered. What is a MOA? We told charter of the company. AOA is called bylaws, rules, and regulation. Now, you can ask me, sir, how simple is this? Why are we wasting time and doing all these things again? Today, you might look, it is easy because yesterday only we covered the portions. But before the examination, you will not have time to see all the provision. Think from that last minute revision angle and then see how useful will this be when you wanted to cover. So MOA plus AOA is equal to constitution of the company. That means this only will cover everything. This is your base document. You remember this? MOA, AOA, SAE, all the documents. Service of document authentication, execution, all that. MOA should be in order only. Classes should be in order. We already told this: name, situation, object, liability, capital, association, subscription, nomination, object or liability. That means connecting with your capital class also. It will be there in which chapter? Chapter number 4, section 61 to 68. Now you will ask me, sir, correctly when we were talking about bonus, we told section 63. Correct? Bonus issue, rights issue, how to alter share capital, all that we told. So it will be there directly under AOSC. What is AOSC overall? Alteration of share capital. Don't you think share capital will change for this? Yes. So name clauses, 5 heads. You remember? You should immediately go to the 5 heads and study. Situation clause, place, domicile clause. We covered this. There is one doctrine for memorandum, ultra vires, 2 doctrines for AOA, indoor management and constructive notice. Tables did we cover? Yes. B and D is without share capital. C and D is with the share capital. Opposite is AOA. You remember all this? Main provision, entrenchment. For what? AOA. Entrenchment means what? Protective clause or provisions which is more than AOA approval. For how you will get approval? All members means 100%. Public means special resolution. Private means 100%. Till this, we have covered it on an high level basis. So what I will do, 5 minutes I will give you. I wanted you to glance this. Now see what I will do. I will show it from here. Okay. So this I will show you. 2 minutes you will glance. Okay. And then I will scroll down. Then 2 minutes you will glance. Or better than this is you can glance your notebook, because your notebook only you should be familiar with. This notes and charts is only for your high level revision. So can you glance this for 5 minutes? Because after that, other provisions I am going to cover. This and all we have not covered. So another 20 points are there that I will cover once you glance this for 5 minutes. We are early, fresh in the morning. Please spend 5 minutes only. Chapter 2 fully you should try to visualize. Please try to do that. Once you do that, it should make your job easy. Then I will cover another 15 minutes. I will finish chapter number 2 and go to chapter number 3. Am I clear? Can you glance this for 5 minutes? Yes, only 5 minutes I'll give you guys. So I hope you should have done with that 5 minutes. This is the last minute revision, but still I thought I can give you time. Yes. If there is a specific provision, now from 48, we'll go for another 20, complete chapter number 2. If there is a specific provision to comply based on MOA, AOA, in such instructions, MOA and AOA will have an effect between liability to members. That's your 48th and 49th and 50th point. What is that? Company is liable to members and vice versa is allowed. But instead of one member, another fellow will not be liable. That is not allowed. So this member, if he wants to go to another member, instead of another member, he cannot take a fraud or a penalty. So members are liable to company, companies are liable to members. But members, for example, instead of Bharati, can I take fraud and can go to jail? No, not possible. But I am binding between both. But what generally they will say is, if at all you have a liability, you will have to be either liable to the company or you should be personally liable. That's all. For others and all, you will not sit and do it. Alteration of MOA, special resolution. We have already told this in the chart. Separately name clause, situation clause, object clause we told. So central government approval is required depending on what type of name change. We told 5 heads are there. Based on that, you will ensure central government approval is required. Central government approval is required for state from when you move from one state to another. You remember, one ROC to another means regional director. One state to another means central government approval. Converting public company to private company, central government approval is required. See how easy. The same place, I am telling where and all the central government approval is required. For all the clauses, members approval, special resolution is required. We told all that. Now, next important MCQ, which we have not told before. That means we have not covered in the main provision. That's only for one-liner. Whenever there is an alteration of MOA and AOA, copies has to be given to MOA. Copies of MOA and AOA has to be given to members. Within how many days? When they requested, within 7 days of the request, along with the fees, you should give them altered MOA and AOA. We have never told this before. 7 days limit, we have never told. So please write down this. We only told one thing. When altered MOA, AOA is done, give it to the members. Give it to ROC. When you want to give it to members, how long you should give it, we never studied in the main book study material. So I brought it under one-liner. So within 7 days, that's what is your MCQ. I always told you should write the number games and practice, which we have already started writing for.
Sir, for both of them, 7 days, sir.
Both of them means what? MOA, AOA.
For both ROC and others, within 7 days.
This is only for members. I'm not talking directly to ROC. Yes, they are saying inform or provide the altered MOA and AOA to ROC. They are saying for members, they are saying 7 days. You should say this and all has to be informed to ROC also. If you are giving it for members, or nothing to think, you will have to give it to ROC. Okay. Change in registered office of the company. We already told a chart. You remember, within the city, within the state, but within the state, one ROC to another, one state to another state, within the town. Correct? All this we have told. Section 10A is crucial. These 2 points are there. What did I tell you for 10A? There was an ordinance passed in 2019. What they did is, if at all you are commencing the business after this ordinance means Avasara Sattam. That means without the parliament, they will try to come up when it is very crucial or when it is important. When the houses of the parliament are not there, they can still pass an ordinance and do it. They are saying if at all you commence the business after 2019, a declaration has to be filed by the director within 180 days from the date of incorporation with ROC, certain documents. Then if that is all allowed, subscription money is fully paid, then ROC is like absolutely fine with the director's declaration. Then only they can go for the loans, borrowings, and other commitments. That means first 6 months, no expectation, Just continue with the business. That's what they are saying. Are you clear? Next. So please mark this. 180 days is very crucial. All number games I am giving a round, so it should be easy to study. Do it like a order. 7 days, 9 days, 11 days, we would have told in different. Similarly, write the forms also. INC 32, 33, 34, 8, 9, 10, 11, all that we told. Correct, 23, 27, all that you write it in an order. Or if you go to MCA, Ministry of Corporate Affairs, full form list will come. In that you select what is based on your CA material or CS material. That is enough, you can study and glance. Subsidiary company, not to hold shares in holding company with 3 exceptions. You remember that 3 exceptions only they will ask you in the exam. Generally, you should not say, we always say law is a 2 side of the coin. Directly, you should not say subsidiary company not to hold a share. With the 3 exception means the other side of the coin. Service of document, section 20, you will provide it. You will serve the documents to whom? Company, ROC, member. To company means registered post, speed post, courier, directly leaving at the registered office. When it is nearby building, you will not send courier. So you will drop it to the nearby place directly going, or any other electronic mode. But here extra post will be added here. So ROC or member post will be there, but this post will not be there in to the company. You should send it only through registered post. Please write this. This 4 is service of document. Write this full. Service of document means members to hold shares more than 1,000 or more than 1% of the total paid up share capital, whichever is less, you will serve the documents. Please write all the 4. 62, 63, 64, 65, write all the 4. This is your section number 20. We always call it as SAE. You remember? Service of document, authentication, execution. I am only doing a one-liner, so I am not sitting and explaining on all this, which we have already done in the class. Authentication, who will, okay, finish writing this, then we will go. Hardly 2 more or 3 more points. Just write this. If you are done, then we'll go to the next point. Let me know if you are done. So if you are done with this, let me know. You are done? Authentication of documents, who will do? KMP, key managerial personnel. You remember the mnemonics that we told, or the shortcuts? See the next one. How to remember KMP very easily. We told as per section 2, subsection 51, you will say 3C, 3 CA, C company secretary, sorry. Yeah. So company secretary, CEO, CFO, C and all will not come. I'm sorry. Because it is external auditor. CEO, CFO, company secretary, manager, managing director, and one whole-time director, or any other person authorized by the board who thinks they are going to be fit. With the common seal means what you will do? An attorney, power of attorney will be given to a person either inside India, outside India. No common seal means there will be authorization by 2 directors. And if there is a company secretary of the company, 1 company secretary, 1 director. That is all is there for chapter number 2. How quick you visualize this? This is going to be very crucial for us to know what is there in chapter 2. I have not covered the explanation of it, which we have already done in the study material itself. Now it is only for your last minute revision. This is a quick demo or a last minute revision for chapter number 2 as how we will cover in the class. Yeah.